พบกับเราทีมทนายความดร.กิติศักดิ์เนติบัณฑิตไทยทนายความวิถีพุทธ
Hi guys, I'm Lawyer Mix from Dr. Giatisak and Lawyer Team. Would like to talk about what to do if you receive a subpoena. And to make it easy to understand this, when you receive a subpoena from the court, please note that you must first understand what type of subpoena is and what you are obliged to do when you receive it. As is, subpoena has a different requirement and different legal consequences. The first one is a civil case subpoena, or it is a subpoena which consists of a copy of indictment. A subpoena and a copy of indictment or a summons warrant in ordinary civil cases will be sent to the recipient with a copy of indictment. After receiving this type of subpoena, you must give a statement to the court within the time specified by law. For subpoenas relating to the civil case consist as follows. The first one is the subpoena states the recipient to give the statement to the court within 15 days. Therefore, if you are sued as a defendant, you must make a written statement to the court within 15 days from the day you receive the subpoena. But if you have not signed a subpoena, the officer will close a subpoena at your domicile. You will be considered that you have received a subpoena after 15 days from the date of closing the subpoena. In Thai, we call this 15 plus 15. And if the defendant did not file his statement within 15 days, the defendant will lose the right to defend himself in the case, which result you to lose the case without trial, or court will testify the plaintiff and make a verdict for the plaintiff to win the case without testify the defendant, and will give the plaintiff an order to proceed the legal execution. The second one is subpoena in petty case. It has several names like subpoena in non-complicated case, subpoena in consumer case. Yes. So, what if you receive this? If you receive kinds of this subpoena, please note that you have a duty or obligation to submit your testimonies and attend to the court on the appointed date specified in the subpoena. And if you wish to defend the case, you must give defense testimonies within the appointed days specified in that subpoena, which is also considered as the first hearing date. And what if you attend to the court on the hearing date? What if you did not attend to the court on the hearing date? The court may consider you to missubmit the testimonies or miss the hearing date, which will result you to losing the case. And the court may decide a final verdict and legal execution warrant. Therefore, if you have received the subpoena, you should contact your lawyer to look after the case and make a statement to fight the case with the time prescribed by law. The third one of subpoena, which is the last type of subpoena, it is a subpoena in criminal case, or in Thai we can call it like a subpoena for preliminary hearing. When you receive a preliminary hearing subpoena, please read all the details and look for the date of the hearing and the material significance in indictment, and consider that you have committed an offense as the plaintiff sue you or not. If not, yes, you have to fight. You have to give a statement to defend yourself. Yeah. But in admissible case, if you wish to compromise with the plaintiff, you can negotiate with the plaintiff to withdraw the case. In admissible case, the Thai law gives the right to the parties to compromise and may have a final agreement to withdraw the case, which legitimately by Thai law. Yeah. In a criminal case with no complaint to the inquiry officer and the victim, as the plaintiff pursue a lawsuit by himself, by the law, the court must conduct a preliminary hearing of whether or not the case has grounds. If the court inquired and decided that it is prima facie, the court will prosecute for further hearing. If the court has made a preliminary hearing and considers that the case has no basis, the court will issue an order to dismiss the case of the plaintiff on that day, which benefits you. Yes. So, if you receive a subpoena, you have to see the details of the date of the trial and should immediately bring a copy of the indictment along with the evidence to consult a lawyer in order for the lawyer to cross-examine the plaintiff's witness on the date of the hearing to make it no ground or basis. When the case has no ground or basis, yes, the court will absolutely dismiss the case. It means you win the case, yeah. On the day of the hearing, you don't need to go to the court, because if going to the court on that day, the court, if the court has made a preliminary hearing and the case has ground or basis, the court will indicate and you will become the defendant and detain it, which you must submit as securities for further bail. Yeah. So please know that when you receive any subpoena, please read all the details and bring that subpoena to consult with lawyer. I, Lawyer Mix of Dr. Ke and his lawyer team would like to thank you for watching this video and hope this video useful and helpful for all viewers. Goodbye.